All right. Hi, everyone. Thanks for joining us today for our Illuminating series. My name's Holly, and I'm the Community Engagement Coordinator here at Lumina. For those who haven't joined us before, this is a monthly seminar that we do every third Tuesday, and we have various topics each time from experts in their field, such as advanced care planning, like we'll be discussing today, grief and loss, healthy aging, and other end-of-life experiences. And so today, like I mentioned, we'll be talking about advanced care planning. And this is the final part of a 3-part series that we've done over the last couple of months on advanced care planning. And so today we're going to be focusing on the financial and legal aspects of advanced care planning. And if you missed the previous ones, if you want to check those out, they are available on our website, and we will send a link out for that with the email that you'll get after today's presentation, which will also include a recording from today. So before we get started here, I just want to do a quick poll to see who is here. All right, you should be seeing the poll on your screen. If you could just tell us, attending this presentation today, what best represents your role. And while you do that, I'll just share a little about our presenters today. So we have 2 presenters joining us for today's presentation. Katie Cole is the first up today, and she is the CEO and founder of Clarity Wealth Development here in Corvallis. And she completed her coursework at the University of Portland to earn her executive certificate in financial planning. And she specializes in working with widows and widowers, folks who are going through some major transitions in life. And we also have Marilyn Brazier joining us, and she's also here in Corvallis with Smith, Davison, and Brazier PC. She has over 20 years of experience advising clients on matters involving estate planning, state administration, tax and business planning, and real estate and commercial transactions. So we are excited to have both here today, and looks like we're just about done with the poll, so I'll end that. And we have mostly interested individuals in the room, and hospice staff and volunteers. Okay. All right. So Katie, I am going to bring you in here. Okay. Whoops, I removed you. Hold on. There we go.
All right.
Take it away.
So you can see my slides, okay?
Yes, we can.
Well, welcome. Again, I'm Katie Cole. I'm a certified financial planner here in Corvallis. And like Holly said, I do specialize kind of towards in the stages, mainly widows and widowers, but I do work with others as well. But when we think about peace of mind and planning for peace of mind, one thing I always encourage people to do is just try to be more prepared. And that's always hard to do because a lot of this deals with some difficult conversations. And as we say, if you're going to climb a mountain, you just need to do it one step at a time. So I'm hopefully will give you some ideas, some tips, some resources to kind of help you go through some conversations that you might need to have, or just being aware of where you may need to get help, or also some ideas on blog posts, books, and things like that. So one of the best options is just to get started. As we go through kind of, we call it the 4 stages of transition. So when you're dealing with somebody who is having health issues or declining, even before something happens, that's kind of the anticipation stage. And then when the event happens, when somebody passes away, that is what we call the ending stage. So you're waiting for something to happen, it happens, and now you're in this new passage. That is one of the largest and longest sometimes going through a transition that's a major event in your life. And depending on how well prepared, that can sometimes be a shorter time frame where you finally get to a new normal. And although it's still difficult, you're not as anxious and things are starting to settle and you're kind of moving forward. So one of the things in that passage stage is where I deal with a lot of people, is just kind of trying to figure out, where are you? What are your possibilities? Where are some opportunities? But also helping manage the chaos. And then it's just kind of going through and focusing on what can be next. So one thing about using an advisor or someone on a team or having other people to go to is helping you recognize your blind spots. We all have them, and many times we don't see them, but others can. And so when you get feedback and you're working with people, it just helps to figure out where those blind spots are. So this presentation, I'm covering a lot on the general level. So just if there's something in here that piques your attention, it's good to kind of start looking into how do you get some good feedback on that. A thought is when you get older and things start to get harder, it's good to start really paying attention to where things are, who is keeping track of things. So if you're in a relationship, are one of you the main financial person? And if you're the other one and you've never really cared or didn't want to know, it's time to really think about, maybe you should kind of pay attention more to that. Doesn't mean you have to know everything. It just means you need to start figuring out where things are. What do we own? Where is it listed? Where are the documents? Where are all the assets? Now, a lot of times we forget we open accounts, or we forget we had an older pension. So it's really good to start digging into where you have things, how are they titled? And then, what are we missing? That's where that blind spot comes in, because a lot of times we don't think through everything. There's social media, there's digital assets, there's things well beyond just your traditional bank and financial advisor and social security. And then when do you bring up these kind of conversations? Well, the sooner the better, as we all know that, but it's a very difficult conversation sometimes to have if you do have somebody who isn't willing to share or doesn't feel like it's necessary to share. But there are some things you can do to at least get a good idea of at least where things are. The other issue we come across is relationships to money. So we all have them, and it does affect your relationship with money. And that's why I have couples where one is really into what we're doing with financial planning and the other one not so much. Sometimes it's just not an interesting topic. Most of the time it's feeling like you don't know enough to contribute to a conversation. And when you look at your relationships to money, we call them money scripts. So a question I might ask you is, what's your first memory of money? Hopefully a few of you are thinking, oh, what is my first memory of money? And sometimes that memory can be positive or negative. And usually that really determines how you think about money and going forward. So it's good to kind of just start thinking through, how do I think about? Is it a burden? Is it freedom? Is it something I can use to get myself further along in life? Is it something I can use to help others? There's unfortunately a lot of negative emotions around money. And so once you start exploring that, it can be very interesting to find out kind of where you land. And then, could you tell someone what you have? It's older generations, taboos around talking about how much money you had grandparents never talked about it. I had parents who were self-employed, and although they didn't talk directly to us about it, we did understand kind of what was going on. But depending on how you grew up, you will have also kind of emotions around money. So getting it together, that's probably the hardest part. Is where do you start? One thing, again, going back to climbing a mountain, don't feel like you have to do it all at once. It's easier. There's books about setting habits. One's Atomic Habits. It's trying to make a chore into a reward. So if it's something you're dreading and you just don't want to find out where everything is or put that all together in one space, it's one thing to just start rewarding yourself if you do one task and make it challenging. Do it with somebody else. It's always good to have an accountability partner. That's, as financial planners, we do that a lot with people, is just making sure they've got things in place and kind of looking at where everything is. And that's where that team comes in, financial advisors, attorneys, CPAs, even friends, family. Although one warning is taking advice from friends and family can be tricky because they're going to tell you what they think versus what's best for you. So, and then don't forget the digital assets. That's, again, social media and things like that. I just listed a few resources here, and I did give Holly a more complete resource list. So she will have, I'll be sending that out, or you can get access to it. But the Life in Motion Guide is one of my favorites as far as how to go through this process and put things together. It's not just where your assets are and what you have, but it also has things in there about if you were in a hospital, what would you want? How do you want your family to deal with certain situations? It's pretty comprehensive, and I like the way it's laid out. It just is, it's a big notebook, but like I said, just take one step at a time. So going back to this, I just real quick, how to organize is finding a system. It can be any system as long as it's all in one place. So in other words, if you have a lot of logins and your passwords are all over the place, and hopefully you don't have the same password for everything. If you do things like LastPass or 1Password, there's a bunch of apps out there that kind of consolidate all your passwords, and there's only one master password you have to remember. And that's a good way to and then you can give somebody your master password so they have access to your passwords if you pass away. Folders, notebooks, journals, anything that just kind of keeps things in one place, or at least let someone know where other things are. And it is good to have it in a home safe somewhere where if there was a fire or something like that, if you have it on the computer, that's okay, but it's good to have a hard copy at least downloaded every once in a while, just in case something happens, you can't get online. And then pick an easy start. Like, for example, one thing is just locating all the statements you have. If they're online, download them, have them all together so you can at least start there. And that's an easy thing. And then you can treat yourself to chocolate, coffee, tea, a walk, whatever it is that kind of reinforces that habit of doing little pieces at a time. And then I think one of the most important things is figuring out your income, your cash flow. Where is income coming from? Where would things stop if I'm married and I lost my partner? What are some things that could happen there? I talk a little bit more about that in just kind of how to prepare for things when you're looking at your income. If you have a pension in the relationship, is it 100% of the survivor, or is it 50%? Commonly, most people do 100%, but it's good to know that. Is your Social Security, if you're on Social Security, how is that set up, and who it's going to be? If you lose somebody, you're going to lose one of the payments. It may, if you're on the lower end of the Social Security, your may increase, but you've lost both payments. There are survivor benefits and some things that go along with that. Do you have life insurance? Is there something to help fund things? Long-term care insurance, that's a tough one because it can be expensive. But there are some hybrids out there that are somewhat better if you have nothing. And then if you do own a home, that's also an asset could be used for that. Burial planning, I think that is really important to do before something happens. Just because when you've lost someone and you're going in to do all the arrangements, you're in a high state of emotion. It's also time consuming and draining on you. So if you do it beforehand, you're usually in a better mental space to make sure you get what you want, and you're not talked into a bunch of extras that you probably wouldn't have paid for if you did it before something happened. Health insurance, that's whether if you are on Medicare, there are some things that are taken care of, but if you're in private insurance and you lose somebody at a younger age, that can be a big piece of missing health benefits is that you were married to someone who had a job, who had the employer benefits, and you lose them, and now you're stuck. That's where life insurance is a big piece of younger couples profiles, not only for the kids, but it's also for the remaining spouse. So the higher earner has that's a better way to do it. And then that just at 65, you do qualify for Medicare, and that makes it a little easier, but there are some other situations that can happen too. One thing, and I'll get to one of those in a little bit, but the benefits, is one of you a veteran? If there's veteran benefits. There's even benefits for long-term care. There is income qualifications, but it's good to check those out and see what you would qualify for. If you have kids and you lose your spouse, there is Social Security payments to the kids. It's usually 50% of the primary insurance amount from Social Security. But I would say for government website, the Social Security Administration website, ssa.gov, is pretty good. And there's a lot of things you can go on there and find out about benefits and things like that. Would you qualify for low income assistance if you lost a spouse that had the income? If you're a stay-at-home person, then that may be something you can look into. Medicaid, also based on income, and then early Social Security, going back to that survivor benefit. Those are some things that could give you a little boost in income. And living arrangements. This is a big one for people who, when you have loved ones or aging parents or people who are far away, it makes it very difficult to kind of help. So thinking about where you're going to live, if you're at an age where things are starting to happen, it's good to realize you have a support team around you somehow, or ways to communicate. There is assisted living arrangements, continuing care facilities. These are outfits that you start in you can start independently, move into assisted, and then move to Alzheimer's or dementia or full nursing care. And then if you live at home, can you bring in home health care or is family nearby? Those all make a big difference in where you land eventually. So it's not a bad thing to plan for before things happen. And then again, going back to income changes, taxes, if you're married, you lose a spouse, although your income changes, you can be in a higher tax bracket actually, just depending on where your income lands. So, and if your spouse is 10 years younger than you, that can make, or 10 years older, it can make a difference in how income's taken from IRAs in the future. And then again, I brought up life insurance before. It's something to protect against assets as well. And then having trusted partners, contact family members. Marilyn will go through a little bit of this, but one of the things we ask is diminished capacity directive. Is there something that says if I start to not be able to drive, if I can't remember things, if I can't do some of the things, what between the family members do you have in place to say, this is the time we need to talk about this? We said this, we talk about where a lot of times a financial advising firm can't talk to anybody in the family if they're not listed on the account. That's a way to add someone on there so that they have somebody to talk to if you can't. And then real quick, silence can hurt. This is a tough one. Myself, times at least a fight, but the more you talk about it, so it is important to everybody. It does get you to a better space. And team, again, CPA, attorney, financial advisor, but there's also other people out there that do a lot of specialty advising, whether it's a healthcare advocate. There's a lot of researchers out there. Trish Law with Comfort in the Journey. I like how she uses, you need to have somebody advocating for somebody's healthcare, burial planning, and of course, hospice. Hospice is a huge part of all this, and I strongly believe in it, and I hope you're all taking advantage of every opportunity they give you to learn. And then back to your why. This is hard to do. But it can be extremely empowering. It can also be a gift to loved ones because you are giving them peace of mind as well as not having to deal with a lot of headaches after the fact when they're the most emotional. I think that's the hardest thing for people. Well, I'll deal with it later. It's not that big of a deal, but you just don't know. And I think bringing people in to confide in them and talk about your concerns, worries is really important, and it makes a huge difference. And believe me, I know I've been there. So plan, you have choices. When you don't plan, somebody else may be taking over, whether you like it or not. And this is who will take care of when I get old. That's kind of a word. So I will pass this over to Marilyn. Thank you very much. And I'll be around at the end to answer any questions.
Thanks, Katie and Holly. Good afternoon, everyone. I'm Marilyn Brazier, you've been introduced to before. I am an attorney here in Corvallis, where a large portion of my practice involves estate planning and estate administration. At the outset, I just want to remind you, if you have any questions, feel free to put them in the chat box. At the end of my presentation, both Katie and I will see what we can do to answer some of your questions. So for my portion of today's presentation, I will talk about creating an estate plan, including, the different options that are available and what's involved with each option. Your estate planning options include, number one, not having an estate plan. Number two, having a will-based plan, having a trust-based plan, and or using an alternative transfer method. So what happens if you die without a will or a trust? Well, your estate is going to pass by the laws of intestacy, which means it may go to people you didn't want to have inherit your estate. And you will also have had no opportunity to do any kind of tax planning. In addition, if you die leaving a minor child who does not have another surviving parent, guardianship proceedings will need to be filed with the court. And even if that minor child has a surviving parent, conservatorship will still be needed if the minor child is to receive a portion of your estate. And of course, probate proceedings will be needed to be filed, and the court will need to name somebody to administer your estate. So in most situations, not having an estate plan is not going to give you the best outcome. So let's move on to the options for creating an estate plan. The first option to consider is using a will-based plan. As you might guess, this involves creating a will, which names the person to be appointed as the personal representative of your estate. The personal representative is the person who will have the responsibility for filing probate and carrying out the terms of your will. Your will also provide for the disposition of all assets that are titled in your individual name at the time of your death. It has no effect prior to your death, and it does not cover assets that are jointly owned or which have a designated beneficiary. The will can also, however, provide for the appointment of a guardian and a trustee to manage the inheritance of any minor child, so that court proceedings for either the appointment of a guardian or a conservator won't be needed. So the advantages of wills are that they're easy to create and they are less expensive than using a trust-based plan. The disadvantages of wills are that they don't provide any protection for your assets during incapacity, and the will must be probated. So having to file a probate proceeding is not necessarily bad, but there are some downsides you should be aware of. These include, number one, it's expensive. For example, here in Benton County, the court filing fees and publication fees just to file the probate are around $1,200. If a bond is required, the premium is likely to be high, and the named personal representative will need to qualify for that bond, which means they must have sufficient assets of their own in order to meet the requirements of the bonding company. In addition, for a probate proceeding, the services of an attorney are usually required, and so you're likely to incur attorney's fees. A probate can also be time-consuming. Usually it takes about 9 months to complete a probate, and also probate cases are public matters. That means anyone can go to the court, look up your will, see the inventory of all your assets, and look at any other reports and accountings that are filed. So in addition to creating a will, there are a couple other documents that are needed for a will-based plan. These include powers of attorney and an advance directive for healthcare. Another document to consider is what we call an appointment of a person to make decisions about disposition of remains, or in other words, to make decisions about your funeral or cremation. The powers of attorney that you will need include, number one, a general power of attorney that names a person you select to have the power to handle finances for you during your lifetime. It's different from your will in that it's only effective while you're alive. The power of attorney will give your agent broad powers to handle all your financial affairs. And because these powers are so broad, banks and financial institutions are often reluctant to accept powers of attorney because they have concerns that they may have been forged or that they may have been previously revoked. So to avoid this, it helps to have the power of attorney put on file with your bank or your brokerage company while you're competent and you're able to certify as to its authenticity. So in addition to a general power of attorney, if you own real estate, a separate real estate power of attorney should be adopted. And this would specifically describe the real estate that you own and states the powers that your agent has over that real estate. You should also have an advance directive for healthcare in order to name an agent who will have the authority to make healthcare decisions for you if you're incapacitated. The healthcare directive will also allow you to make end-of-life directions as to the use of life support and tube feeding. And then for those of you who already have healthcare directives in place, you should know that Oregon revised its healthcare directive form last fall. So now there are many other options and information that you can include in the directive. The next option to consider using to create an estate plan are trust-based plans. These involve the adoption of a revocable living trust. A living trust differs from a will in that the trust is effective immediately, and it includes instructions for your care during any period of incapacity, as well as for the distribution of your assets on death. So this makes it easier for your named agent, a successor trustee, to manage your assets during your incapacity, and it allows you to avoid probate. The living trust is also revocable, so it can be changed or amended at any time during your lifetime. You know, a living trust is sort of like a bucket where the trust maker creates the terms of the trust, puts property into the bucket, and then the beneficiary at the end receives the contents of the bucket. So the initial parties to a living trust will include the trust maker. This is the person who creates the trust. The trust agreement that contains the instructions for the trust. The beneficiary, who will during your lifetime be the trust maker. And then, of course, the trust must contain assets. Getting the assets into the trust is one of the bigger steps because they must be retitled to the name of the trust. To do this, it's important to create an asset list, review the titles to all your assets, and have them correctly retitled into the name of your trust. Since your living trust is effective immediately and it's in place during any period of incapacity, the living trust should contain instructions for your care during incapacity. For example, it can state whether you want to stay in your home or move to a nursing home. It can provide instructions for the payment of your care and continuation of insurance. Also of importance is whether your trustee is to have any authority to make gifts to family members or to charity. If nothing is said, then your trustee will have no power to make any kind of gifts, and they will only be able to use the trust funds for your individual benefit. So the advantages to a living trust are that detailed instructions for the care of the trust maker can be included. So this helps avoid any need for a court-appointed guardian or conservator on the incapacity of the trust maker. And it can also provide for a continuing trust for any minor beneficiary. Probate can be avoided, so the terms of the trust remain confidential. Also, the time and steps required for administering a trust on the death of the trust maker are fewer. So they're fewer than what's required in a probate proceeding. So the distribution to beneficiaries is usually quicker. And since probate's avoided, the costs of a probate filing are also avoided. So the disadvantages of using a living trust are that, number one, a lot of upfront work is required. Your assets will need to be retitled in the name of the trust, which means changing the deeds to real estate and the names on bank and brokerage accounts. For life insurance, the beneficiary designations are usually changed to name your trust as the beneficiary of the policy, so that the funds from the life insurance can flow through your trust and be used for specific purposes. And then the cost of setting up a living trust will be much higher than the cost for setting up a will-based plan. For a trust-based plan, it'll still be necessary to adopt a power of attorney to cover those assets that are not included in the trust, such as retirement benefits and life insurance. And it also will authorize your agent to deal with government entities such as the Social Security Administration and to file tax returns. Also, a healthcare directive and an appointment of persons to make decisions about your funeral will still be needed, just like a will. Now, one big issue to address when making a decision about what type of estate plan to use are taxes. Both federal and state estate taxes may be imposed on your estate on your death. Currently, the federal estate tax only applies to very large estates. For the year 2022, the federal estate tax is only imposed on estates in excess of a value of $12,060,000. However, the statute as written is going to revert to 5 million plus an inflation amount as of the year 2026. This is projected to be around $6 million. So at that point, the federal estate tax will pick up more, but still not that many estates. On the other hand, the Oregon estate tax is imposed on estates in excess of $1 million. And so it applies to many more estates than the federal estate tax does. Luckily, the Oregon estate tax rates are not that high, at least not on estates just over the $1 million limit. The tax rate starts at 10% and it goes up to a maximum of 16% on large estates. So as for what you can do to avoid or minimize estate taxes, for married couples, a joint living trust can help. A living trust can provide for the creation on the death of the first spouse of what we call a bypass trust. A bypass trust is essentially a sub-trust within the living trust, which will hold a portion of the trust assets following the death of the first spouse. And it's structured so that the assets are held for the benefit of the surviving spouse, but they're not considered the surviving spouse's own assets. So they're not taxed on the as part of the surviving spouse's estate at the time of their death. The tax savings from using a bypass trust can be up to $100,000 in Oregon estate tax. And if the estate is large enough to be subject to federal estate tax, the savings can be much more. So for minimizing Oregon estate taxes, another planning option is through gifts made prior to death. Oregon does not tax gifts, so unlimited gifts can be made to reduce a person's estate for Oregon estate tax purposes. On the other hand, the IRS does tax gifts. So if a gift is made in excess of what we call the annual exclusion from gifts, a gift tax return needs to be filed with the IRS, but not with Oregon. The annual exclusion amount for the year 2022 is $16,000 per beneficiary. So to avoid paying gift tax, federal gift tax on gifts in excess of $16,000 per year, you can elect to use some of your lifetime $12,060,000 exemption from gift and estate taxes to that particular gift in order to just wipe out the gift. Now, one important thing to remember about gifts is that there is what is called a carryover basis for lifetime gifts, while gifts made at death get a step up in basis to the then fair market value of the property. This means that if you give property away during your lifetime, your beneficiary, if they turn around and immediately sell that property, they may end up having to pay capital gains tax. This is because their basis used for determining whether they realized any gain on that sale will be whatever basis you had in the property. If instead that property was inherited by them on death, it would have received a step up in basis to its fair market value at that time. And if the property is immediately sold, capital gains tax may be avoided. So in lieu of, or in addition to using a will-based plan or a trust-based plan, there are alternative methods for transferring property at death. One method is to own property as joint tenants with right of survivorship. Now, this method can work just fine in the case of a husband and wife. Probate can be avoided on the death of the first spouse, and so only on the death of the survivor will the asset have to go through probate. On the other hand, joint tenancies with somebody who is not your spouse can be more problematic in that bank and brokerage accounts, with bank and brokerage accounts, either owner can access the account and remove all the funds. Also, the creditors of either owner can attach the funds and remove them all in the account. The other issue is that if a non-spouse is a joint owner of an asset and they die first, the entire account or property will be included in their own estate for estate tax purposes. So you need to be very careful about who you add to your accounts and how much of your property is in joint ownership if it's not with a spouse. The other common method of transfer is to add a beneficiary designation to certain investments and accounts. This is usually the preferred method of dealing with retirement accounts, as it will help preserve the tax deferral that may be available to your beneficiary. It's also a simple and convenient way to arrange for the transfer of an investment or an account to a particular beneficiary without incurring the risks associated with joint ownership or having to go through probate. The downside to using a beneficiary designation is that on your death, the asset will be immediately transferred to the named beneficiary, which might leave your estate without enough funds to pay your funeral expenses or any debts or taxes that your estate may owe. If other assets do exist, all those debts and the entire estate tax burden may have to be paid out of those assets. This might create an unequal treatment, between the beneficiaries who receive probate assets and those who receive assets by beneficiary designation. So the other risk on top of this is that if the named beneficiary should die before you and you didn't update the forms, the default provisions in the financial institution's own documents will determine the next beneficiary. If instead, those funds were going through your will or your trust, you would have named in those documents the particular successor that you wanted to receive the funds. So in summary, although they can be useful, you need to be careful how you use beneficiary designations and make sure you think through all the consequences in advance. So this brings me to the end of my talk. We thank you for attending. If there are any questions, you can enter them through the chat box, and Katie and I are going to stay around and see if we can answer them. Turn it over.
Okay, I'm gonna add Katie in here. So we did have a couple questions come in. There you go. Okay. I'm gonna kind of work backwards on the questions here. So Marilyn, we were talking about retitling, making sure you retitle with the trust. And a question came up, if there are any assets and it doesn't get retitled, would they have to go through probate, or what might happen in that situation?
Yeah, so if the assets are not retitled and they don't have a beneficiary designation attached to them, then they will have to go through probate. So when we set up trust-based plans for our clients, we also run off what we call a pour over will that says, oh, if we miss something and this asset and an asset goes through probate, we want that asset to be poured over into our trust. But yes, the goal is definitely to make sure the assets are either titled in the trust, or if appropriate, they have a beneficiary designation.
Okay, thank you. Another question for Marilyn: if you don't have an executor or a backup for an executor for a trust, who could do that role? Who could you turn to fulfill that role?
Yeah, if you don't have anybody, you may turn to, there are professional, there's first of all, there are trust companies that will, and banks that will serve as trustees, but you've got to have a fairly large estate to qualify for them or to make it worthwhile. But there are fiduciaries, professional fiduciaries in the state of Oregon, who are either attorneys or CPAs, who are willing to act, or they provide trust services. And so they charge a fee. That's usually on an hourly basis, but they exist.
Okay. Another question came in: if we have a family member with no spouse or children, and their only assets are a house and a vehicle, is a will better to manage their assets and death?
Yeah, I'd have to know more. Yeah. Obviously, yeah, if it's a fairly simple probate, that's one factor to consider. But I'd really have to know about the circumstances, who would inherit, whether there's other issues out there.
Okay. Next question. How do you determine whether real estate property is held as joint tenants with rights of survivorship?
You have to look at the deed. It'll say whether it's tenants in common or if it's if there's a right of survivorship.
Okay. Question, how can I learn more about healthcare advocates?
So one thing is online is not a bad place to look, but there are websites, AARP, American Council on Aging, and even just going through, I think the website Comfort in their journey is not a bad place to start as well. But also just asking local people too that are in the senior living. There's sometimes resources in those facilities that can lead you to a healthcare advocate.
Okay. Let's see, we had a hand raised. Where did it go? Okay. Tamara has a question. Let me see if I can unmute you here if you want to.
Hi. It was just, I'm so sorry, I missed the bulk of the presentation. And I was just curious about this presentation, if it's something that we can be sent by email.
Yeah, so anybody that has registered for the presentation today will get an email, have these slides in it, some resources that Katie and Marilyn have shared with me, and then a link to view the rest of the presentation, a recording.
Okay. Thank you so much.
Yeah. Okay, next question. Is there a good resource online where people who are low income could go to find out about wills and trusts? For example, there's the low income folks who have some property, but who would have trouble affording an attorney.
Yeah, off the top of my head, I don't have a specific resource. I would contact the legal aid. They've got attorneys available for certain purposes, so I'd probably start with them.
Okay. And Cheryl, yeah, Cheryl commented, you can get Oregon's advanced directives online. One of our previous presentations in this series was all about advanced directives and post forms. So we'll include how you can view those previous presentations as well. And that has some really helpful information in there.
I have a question. This is Robin. My question is that I'm pretty familiar with the Oregon Advanced Directives. I did go to the hospital's health education center and picked up the forms. But then later on, ARP was doing a town hall, and one of the town hall representatives last year was one of the new, she was a freshman. I think she was a freshman state legislator or congressperson. And she said that they had adopted, the legislator in the short session had adopted changes to the advanced directive. So instead of you having to check mark, you could actually be a fill in the blank. And I'm waiting for that supplement to be available. And I haven't been able to find that, the newest form, I guess is what I'm saying. So when you mentioned that there was a form out there as of September 2021, is that the form that has that change? That has the ability for us to fill in what we want in a narrative way?
Yes, it is. We found it in the statute. If you go online to the Oregon Revised Statutes, the whole form is in there. Yeah.
I'll go there then. Thank you.
Mm-hmm.
Okay, we have another question here. Can you say more about the use or need for a pour over will if a trust exists?
Oh, it should be just, you should always have it just as a backup. You know, it's a 2-page document. It's really not that involved to create.
Okay.
You know, hopefully you'll never need it, but it's there in case something goes wrong.
Okay, and then have another question about paying for, we talked about planning for a funeral or cremation, but are you able to pay for those things ahead of time? And is it recommended that you do so or not? Things are constantly changing. So I guess what's the recommendation on paying ahead of time for things like that?
Yes, you can pay for those ahead of time. And one thing too is somebody asked about Medicaid too. So if you do have someone that would qualify for Medicaid, that's a good way to use some of their assets to prepay for a funeral. But again, the other advantage for anybody is just doing it before you have to deal with it later. But yes, you can prepay that. And I know somebody else asked about how to find out information about Medicare, and I didn't put that in my resource list, but everything's state specific, so you want to be very clear. And there is a 5-year look back, so you don't want to be giving away assets 5 years before you declare Medicaid. And then Marilyn, I don't know if you want to talk about the qualified income trust, but that is one way to help. However, anything left over in that usually goes to the state of Oregon. So I don't know if you want to add anything on that, Marilyn, but.
Yeah, I would say talk to a professional before you really get involved in trying to set one up, because there's a lot of potential landmines that you want to make sure you clear and not end up disqualifying yourself for Medicaid or having them make a claim on that trust. So yeah.
Okay.
I have another comment. This is Robin again. I'm an SSI disability person, and I didn't find out until late last year that SSI is very restrictive on assets. You can only have $2,000 combined, including cash on hand. But I was found out that you can actually have a burial expense or funeral expense account up to $1,500 saved, which does not count against you. It's not part of that $2,000 income. So I set that up, and she told me I needed to have an account designated like that. Well, when I went to the banks, including my personal checking account, they said I had to have a living trust to do that. They no longer did funeral accounts. So when I went back to my claims representative, she said, oh no, all you have to do is just designate it that that's going to be your funeral. So I used my credit union savings account as that. So in that case, if I was to have a will or a living trust, I definitely would have to specify that that savings account was for funeral expenses, even though it may not be titled as funeral expenses on the on the savings account? Or do I just list it as an asset and just market the beneficiary to the person who I would like to be my personal representative? Am I making sense?
Yeah, you're making sense, but I'm not sure. Yeah, I would.
Because it's technically.
It seems to need to be a restricted. I would think it would need to be a restricted account. Otherwise, it has to go through, or probably just a small estate affidavit would need to be filed. But
okay, I was just curious because, like I said, Social Security informed me that, but then when I told her the restrictions I had and it would cost me money to go get an attorney to do a living trust and all that, she said, oh no, just tell me what account it's going to be, and then I just make deposits into it and don't take any withdrawals out of it. Yeah. So I thought, okay, but it's still just a basic savings account.
You certainly don't need a living trust to have to prepay, have a prepaid burial account. Okay. Katie, do you have any thoughts about how these are typically titled or created?
I don't know if I have anything that's typically titled. I know I was just trying to look because I had just looked up some things about Medicaid, it doesn't really say. So I don't know if just having it in a different title with the document that just says it's restricted. I don't know. I'm not.
I know it is confusing because I'm not 65, so I still have Medicaid insurance. And because I turned 65 last month, they're forcing me to take early Social Security because my early Social Security benefit is higher than the maximum SSI benefit. So
Right.
it's kind of, yeah, it's complicating my life in ways that I wish it didn't, because I've learned how to manage on. So, and I have to wait now until August when I get my first Social Security early retirement. And that kind of, to me, removes my disability, even though I'm still disabled. And then that changes, gives me an extra $500 more a month. And I have to wait to find out whether I'm still Medicaid, even though Social Security told me I'm Medicaid and not Medicare. And so it's really confusing to me because I've been disabled more than 2 years, but I'm not under SSDI. So I don't convert to Medicare under 65. I have to wait till I'm 65. So
Yeah.
it makes it really complicated. And they don't explain any of that to you until you're in a mess. And then they're like, oh, that's just how it works. I'm like, well, I wish you tell me this beforehand so I can plan, Social Security is not very, and I've checked out their website, believe me, they're not very forthcoming with information, and it's not always the same information when you ask more than once and different people. So I don't really, I trust them, but I have to, but I don't really trust them, if you know what I mean. I don't feel like they're the only answer. So.
Yeah, well, I would look at that website I put up there, even though that was specifically for Medicaid eligibility. That's website's put on by the American Council on Aging, and there might be some more stuff in there too.
Okay, one last question and then we'll finish out here. What is the most efficient way to update a trust?
Simple amendment to the trust would be all that's needed. I mean, it depends on how extensive the changes you want to make are, but if they're fairly simple, it could be a one-page amendment.
Mhm.
It does need to be signed and witnessed and
Well, when we reached out to do that, what we thought would be just a simple beneficiary update, the attorney we talked to said that there had been so many changes in the tax codes and everything from 2016 to 20 that there was a lot that needed to be redone. So is that not such accurate information, or?
I'd have to look at your trust
Yeah.
to see how specific it is about estate taxes. And also we'd have to go over the assets, but in general, since 2016, the changes have been really the federal and the increase in the exemption, year to year. And so it would depend on how your trust is worded, but it may just have a general formula that picks up whatever estate tax exemption is then in effect. I guess I can't comment without seeing your trust.
Yeah, but in general, just not redoing the whole thing, but just an amendment maybe is all it might be.
Yeah. I mean, if it's a perfectly valid trust and you've got just one change to it, a simple amendment should be all that's needed.
Okay. All right. Thank you.
Okay. That is all the questions I see in the chat. So we will wrap up here. Thank you, Marilyn and Katie, for presenting and fielding all of our questions today. Just a quick announcement about the Illuminating series. We'll be taking a short break for the summer. So keep an eye on your email inboxes, and we'll be sending out an invite for you for September when we meet again. So again, you'll be getting these slides, some of the resources, and as you can see, it's got the contact information for presenters on here. So thanks everybody, and have a great day.
Okay, thank you.